call this meeting of the West Hollywood Rent Stabilization Commission to order. Please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Staff, can you hear me? Is my mic on? It doesn't sound on. I can hear you. Yeah, it's green. That's why yeah. Thanks a lot.
They don't seem to be on. Are they on? No.
Testing.
Testing.
Yeah.
Can you hear him out there?
Hello. No.
Okay.
Mine, is it working? Mine isn't working.
Mic system. It's
Okay.
just from okay.
Sorry,
'Cause there's
clarify that.
We'll keep working on it.
Okay, so we can just continue and we'll just project.
Project.
Okay, Secretary Brino, may we have the roll call?
Commissioner O'Keefe. Commissioner Kerpes.
Here.
Commissioner Maggio. Commissioner Martz. Here. Commissioner Topchian. Vice Chair Bergstein.
Here.
Chair Charity.
Here. Thank you. Moving on from item 3 to item 4, approval of tonight's agenda. Commissioners, having reviewed tonight's agenda, do I have a motion to approve or any amendments? Thank you very much. All those in favor, please say aye.
Aye.
Thank you very much. Moving on from item 4 to item 5, approval of the minutes of our last meeting, April 25th, 2019. In our packets, we had Commissioner Bergstein's mother, the adjournment motion not cited. Oh, I do see it here, but was it incorrect?
Just her middle name was incorrectly spelled. That's been corrected. I appreciate that.
Thank you very much.
I'd move to accept the minutes as submitted.
No amendments. Very good. Thank you. All those in favor, please say aye.
Aye.
Thank you very much. Moving on from item 5, approval of the minutes of our last meeting, to item 6, public comment. I have no public comment in front of me. Is that correct, staff? No. Moving on from item 6 to item 7, our director's manager's report, and we'll have that from our housing manager, Mr. Peter Noonan.
Good evening, and hopefully while we're speaking, perhaps one of the technical staff here can come help us out with the mics so we can get those on and working for you. Looking at the calendar, we still have double appeals coming up at the next meeting, and on May 23rd, June 13th, June 27th, and July 11th. We will be announcing the annual general adjustment as we do each year at the June 27th meeting. And then there'll be the reorganization of the chair and the vice chair at the first meeting in July, and the second meeting in July is scheduled as your study session. This concludes my report.
Thanks very much, commissioners. Do you have any questions or comment for staff?
One quick one. I know I should know the answer to this question, but a constituent texted me and asked, how many rent-stabilized units are in the city of West Hollywood? My guess was 13,000. Am I close?
Yeah, so the question is, how many rent-stabilized units are in the city of West Hollywood? We have close to 17,000.
Thank you.
Thank you. Commissioners, anything further for staff? Very well. We'll move on from item 7 to item 8, commission comments. Are there any comments from the commission at this time? Thank you.
Do we have a microphone? Yes, we do. Okay.
Thank you.
Here we go. There we go. Okay. So. Oh, so this is not working. We're seeing if we can get staff over to help out with the
Good evening. I feel like I'm going to sing a song. What tune would you like to hear? I thought it would be appropriate at this time to let the Commission know that as liaison to public facility, I did attend it last night, and they were televised here last night, and they were very excited about it. And we have a lovely new commissioner. Her name is Elaine Polchik, who was actually the assistant city manager for the city of West Hollywood, so she really comes to the table with a great deal of knowledge. And two of the topics that one, I participated in the new business, which was the Sunset Street Scape pilot. And because I lived all my life on Sunset Strip, I found it very interesting to know how they're trying to redesign it and give it a more walking concept and creating parklets. Although it's a pilot program and there were a lot of people still opposed to it, so it's an ongoing project. And the other, which was unfinished business, was the urban forest management plan, and that really involves planting more trees and replacement of trees, which I think is one of West Hollywood's greatest assets as Beverly Hills. Think of all the wonderful oxygen it creates, but the dispute is really what kind of trees. So I don't know how to get into that, but as I go, I will be able to report back, and I told them I would be reporting housing issues and that are germane to their commission as well. Thank you very much, and I'll pass. Do you need it as the...
Thank you, Commissioner Maggio. Commissioners, any further comment during commission comments? We'll pause just for a little bit for staff and to welcome Commissioner Topchian. Commissioner Topchian, our mics aren't working, so that's what we're having a little bit of technical difficulty. Well, at this time, then we'll proceed. We'll move on from item 8 to item 9, our first appeal of the evening, item 9A, D-4389. The address is 1155 Hacienda Place, Unit 107. This appeal was filed by Scott Brody. Mr. Brody, are you present or having a representative here? Thank you very much. The opposing party would be Don Robinson. Don, are you present? Thank you very much. At this time, we'll have a report from staff.
Thank you. The hearing examiner awarded tenants at the property a rent reduction for a substantial decrease in the pool furniture. The landlord has appealed and argues that the evidence does not support the rent decrease. Staff recommends that the commission affirm in part the hearing examiner's decision. There is no dispute that most of the pool furniture was removed in the summer of 2018 when an enclosure was placed around the pool. At the hearing, the landlord testified that new furniture has been ordered but not yet delivered. Thus, the hearing examiner's determination that there's been a substantial reduction in this housing service is supported by substantial evidence. But staff recommends that the commission reverse the hearing examiner's valuation. She awarded 2 rent decreases for the same housing service. The rent stabilization ordinance authorizes 1 corresponding rent decrease for the removal or substantial reduction of a housing service. Thank you.
Thank you, Ms. Regan. Commissioners, do you have any question or comment?
Ms. Regan, hi. If we are granting only 1 rent reduction, this $5 rent reduction was suggested by staff, right?
That's correct.
Okay. So what was the, can you just explain how you arrived to that $5 rent decrease amount?
The hearing examiner had determined that administrative precedent in this type of cases supports a rent reduction of $7. And so given the facts surrounding the case, as I set out in the appeal, given that most but not all of the pool furniture had been removed and the ones that remain are not in perfect condition, it seemed appropriate to deviate slightly from the full rent reduction, but also to give a substantial rent reduction.
Okay, all right, thank you.
Does this work now?
No.
No, it's not working. All right, and you could hear me? Oh. I'm just curious. I didn't see it in the record, but would there be any reason that less furniture could be put in that patio area because of the new fencing?
Yes, so part of the evidence in the record is that the enclosure substantially limited the amount of furniture that could be placed outside the pool area. If you read the hearing examiner's decision, she goes into the limitations placed by the barrier.
Thank you very much.
Commissioners, anything further before we proceed? Okay, very well. So our parties this evening, you each have a total of 5 minutes to speak. Mr. Brody, as the party that filed the appeal, you're able to split your time to rebut your opponent's testimony. So you're able to let our secretary know when you start speaking if you'd like to perhaps, for example, speak for 3 minutes and then save 2 minutes for rebuttal, but you're able to split your time. Please understand that we're not able to accept any new evidence, and please try to speak directly into the microphone so we can hear you.
Sheridan, can you give me just 1 minute? They're in the wrong mode. They're in the public art mode, not the meeting mode. Sure. Take me just a minute. The system has to shut down and warm back up. So.
Thanks very much. Okay, testing. Thanks.
Ready? Oh, it's ready.
Okay, so yes, Mr. Brody or your representative, could you please come to the mic? And as I said, please state your name and please try to talk directly into the mic. Thank you.
Good evening. My name's Scott Brody, and we are the third-party property management firm for the building at 1155 Hacienda.
Thank you. If you'd like to delineate your time, you can let Secretary Barrino know.
Sure, I'll split my time. There's not a lot I'm going to say. So, sure. So, the appeal was filed. We, obviously, it states that we agreed we took furniture away. Let me give you a little backstory. Our insurance company was actually canceling our policy for the building, and most insurance companies are following suit with buildings that have pools that are open. They said, you got to put a fence around your pool, safety. So we in turn put a glass enclosure. The client of mine actually spent a substantial amount of money. They didn't want to put a chain link fence, so we put a glass enclosure around the pool. Most pool furniture won't fit outside of the glass enclosure because that's the ingress-egress walkway to get into the apartments on the lower level. So we were very limited in terms of what we can put within the pool. So the current furniture we had didn't fit outside or inside. So my client ordered all new furniture, substantial cost to him. First furniture he bought, he realized wasn't going to work either. So then he had a special order furniture. The furniture he ordered, the first go around was from IKEA. So the furniture that's there now, which was delivered, I think, over the last week or two, 14 lounge chairs, 2 tabletops, and 4 chairs. I don't remember what was there prior, nor I don't know if that even matters. The hearing officer at the time seemed to think that it did matter. However, the tenants that live in the building are staggered in terms of move-in from 30 years ago to a week ago. And so the guy that moved in 30 years ago may have had a table, but didn't have 18 chairs. The person that moved in 8 years ago may have had 18 chairs when they moved in. So what's being determined in terms of taking away service? The guy that moved in 30 years ago, his expectation was he had one table. The person that moved in 5 years ago, their expectation when they moved in was a full set of pool furniture. So my conclusion was it's hard to determine what's being lost and what's not. I understand we took away pool furniture. We had to take it away because we had to build the pool.
That'll be your time. Commissioners, questions? Yes, Commissioner Bergstein.
So if I'm reading the record correctly, it sounds as if the original furniture that was removed prior to the new fence enclosure being built was approximately 9 lounge chairs, a love seat, 2 chairs, and 2 tables for seating for about 14. And the furniture that was in place at the time of the appeal, nothing that's been delivered since the appeal, because that would be new evidence, but at the time of the appeal, I'm calling it post-new fence, was 4 lounge chairs, a small table, which meant that 5 lounge chairs were not returned, the love seat was not returned, 2 side chairs were not returned, and 1 table was not returned. Does that sound approximately correct? Best of your knowledge.
I guess, but what you need to clarify is the furniture that was removed prior to the fence, that wasn't there 20 years ago. That was different. So
I'll just interject. I have 2 lists here. I have an initial listing from many years ago of 3 round tables, each
Right.
with 3 to 4 chairs and 6 lounge chairs. So I
that's
put.
not in, that's
let me
not
finish
in,
my. Let me
that's
finish.
not in dispute. We had a tenant show up to the original hearing
So let me just finish.
bringing
so,
a
let me finish my
picture
sentence.
of when he moved in, and it was a table and a couple chairs. So his expectation of
Can I finish
of
my?
the
Can I finish
amenity-
my question, sir? Okay, so that initial furniture, the old furniture, let's put it that way, was sitting for approximately 18. That was the round tables with the chairs, 6 lounge chairs, and then the more current old ones, pre-construction, gave you seating for about 14. Does that sound about right? Between the lounge chairs, the love seat, and the chairs?
Maybe.
Okay, thank you.
I didn't see any evidence in the record of you submitting rent rolls or any, because I know during your appeal testimony right now, you talked about some tenants being older tenants and some being new, but did you submit those?
No, because I didn't know what was going to be presented, and the hearing officer asked if I can sit it after the case, and I didn't submit it. I mean, that would be the only way to determine who's been taken away at what level of furniture that was removed.
Yeah, I just wanted to know if we were missing anything.
Yeah.
Commissioners, anything further? Commissioner Martz.
She did ask me, I'm sorry, the mediator or the hearing officer did ask me which units were vacant at that time, and I read into record which ones were vacant. I think there was
And
a
we
total.
have that.
Yeah, there was a total of like 5 or 6 vacants at that time.
All right. I see in the record there's an email from Don Robinson, who is Don Robinson? That's Don. All right. And who is Diana Matthews?
Diana was an old employee of mine.
And no longer. Okay, so she wrote in June 2018.
Who's she?
Diana Matthews, if the owner does not want to purchase furniture, he is not required to do so. Is that your premise as a property manager, or, I mean?
Was a part-time assistant, so.
That's my question. No, my question is that the rule that you follow? Is that something that you still stand by if something's taken away?
I've never claimed that. I've never said that. That was a part-time person.
That worked
was
for you, though.
She was a temporary employee, so, yeah.
Okay, all right. And then one of the concerns I have here is that this matter seems to have gone on from Dawn emailing in 2017 up until mid-2018.
The fence itself, from the time it was installed to the time they got the final permit, was almost 11 months.
Okay. That's all the questions
City
I have.
kept asking the contractor we hired a contractor to do the job.
I understand.
Yeah.
Okay, thank you.
Commissioners, anything further? Yes, Commissioner Maggio, thank you.
In our exhibits, we have a photograph of the new glass fencing.
I don't know. Yes, that's.
And I'm curious, has it been considered to put any furniture on the other side of this glass? Because I could see room has been changed. Yeah, you may look at this.
So you're asking if you can put furniture outside of the glass?
Since
There's no room to put it. It's literally you walk out of a tenant's apartment and there's literally there's 3 feet for the walkway.
But I mean, in this front area, this is the
That's
entrance.
the lobby.
Okay, that
That's
clarifies.
not, yeah, that's just the entry of the building.
Thank you very much, sir.
Commissioner O'Keefe.
And I'm basically certain of this, but I think you said that now there has been ordered seating for 14, which you think that there would be room for, correct?
I'm sorry, I couldn't hear you.
There's that echo. I don't know if there's another.
Yeah,
mic.
you're
I think
on.
it's your mic. Now, 14 pieces of furniture, enough to seat 14, has been ordered, and you expect there to be room for those, correct?
There's currently 14 lounge chairs, 2 tabletops, and 4 large, the tabletops are bar height, so there's 4 bar height chairs. Those are all new that have recently been dropped off and put around the pool, within the glass enclosure. Yeah, so that's all the new furniture. I think one table was missing some screws, so one tabletop may not have been installed yet, but it's all on site.
Commissioners, anything further? Very well. Thank you, Mr. Brody.
You're welcome.
At this time, Ms. Robinson, you'll have 5 minutes to speak.
Good evening. My name is Dawn Robinson. I have lived at Hacienda Place since 2006. Thank you for recognizing that I've been working on this for 2 years. It's really, really, really frustrating. I was working full-time, and so, it took a year. I was like, oh, hey, I noticed cleaning out my emails that we still don't have this furniture replaced, and it was just worn and nasty. And I got that response, and no other response from anyone else at Scott Properties. We were told that they were going to build a fence. 2 weeks before Memorial Day last year, they took all the furniture away. They didn't start the work until almost 3 weeks later. So we were like, hey, we don't have any furniture, and summer's here. So I think they finished the fence in like a couple, 3 months, and then they put back those 4 or 5 chairs at the most. But we really enjoyed, we would sit out and have coffee in the morning on the sofa. We would have wine in the evenings. It was just much more of a community area that we actually enjoyed before it was taken away. People actually use the lounge chairs around the pool during the summer or when it's sunny outside. We have no lounge chairs now. None, no chaise lounge. They're all just chairs. We have a nice high top. No one's complaining about the fence, but we'd like to have the furniture that we've enjoyed for the last 12 years back. And prior to that, when they replaced the furniture, it was something different and better, but equal. It wasn't completely different and not useful.
Thank you very much. Commissioners, do you have any questions for Ms. Robinson?
Could you just say that last part again? I didn't quite understand it.
Well,
What they replaced it
he
with?
said, so I've lived in the building since 2004, and he said that the furniture has changed. Yes, it has. We used to have just like patio furniture with the round tables and chairs and umbrellas, and then some chaise lounges.
Mm-hmm.
And then they replaced the round tables with the love seat, 2 chairs, and a coffee table by the pool. okay, that's fine that you took those away and you added more chaise lounges so more people could lay out. So it wasn't like we were losing out or missing anything, because we all enjoyed that furniture. The chair, well, that's new evidence, but we literally have no chaise lounges now.
But at the time, yeah, I was going to say, at the time of the hearing, you did feel that there was a reduction.
Yes.
Okay.
So what we have now is not useful at all.
Thank you.
Yes.
I have a question. Just for clarification, you started off your comments by saying you moved in 2006, and
Yes.
now you said 2004.
So I have my own unit since 2006. In 2004, I had a roommate and I was sharing a room there.
All right, so
But I
you-
moved into 107 in 2006.
So you've been on the property since 2004?
I've been on the property since 2004, yes, sir.
Thank you.
Commissioner O'Keefe?
At the time of the hearing, or at the time that you filed for the hearing, did you feel like there was room for more furniture than was there at the time within the enclosure?
I feel like it wasn't planned well, this fence, and there's space for furniture if you measure and actually spend substantial dollars on it instead of going to IKEA. You have to plan for it to be the correct furniture to go there. But yes, there can be. There's room. My neighbor and I host Thanksgiving every year. This year we had 32 people. We have 2 long tables that went on the other side of the fence, and 14 people sat outside along that, and there was plenty of space for people to walk by, etc. So you have to plan it and, be considerate of people.
Commissioners, anything further? Very well. Thank you, Ms. Robinson.
Thank you.
We'll move on to commission deliberation. Oh, sorry, rebuttal. Oh, sorry about that. Rebuttal. Thank you.
Thank you. So first of all, the fence was put up by a licensed contractor, and the city approved it. There was nowhere else to put the fence. And so the way the fence is positioned, when you walk outside someone's door, there's literally 3 feet, there's 3 feet of walkway. You can't put any furniture between the fence and the tenant's doors. There's nowhere to put it outside the fence. Inside the fence, a normal-sized chaise lounge doesn't fit. There's not any room between where the water is and the back of the pool. So what we did was we purchased 14 chaise chairs. So they fold up where you can, they're not a chair where you sit in. It's called a chaise chair or a lounge chair. So we purchased 14 of them. They're spread all over the pool. There's more chaise chairs than there was chaise lounges. We added an extra table. That's as much furniture that's going to fit within the pool. In terms of what tenants do outside that glass enclosure, if she's having Thanksgiving Day dinner and putting tables outside of an area that is not really supposed to be used for parties, etc., that's something new that we didn't know about. But anyways, there's no more room for any furniture. I can't put a chaise lounge anywhere in that courtyard. It won't fit, period.
Thank you. Commissioners, questions? And just to clarify, when you're saying chaise lounge, you basically are just saying one that doesn't fold up and down, because we have a picture of ones that, what you've seen earlier with the fence, where they, fold up and down, and that's what you're saying you have 17 of, correct?
Yeah, and the chairs are put on the stand, so yeah.
Okay.
So these are the chairs, yeah.
Oh, I see. So it's something like what we see in our packet,
Those won't fit on the sides.
That won't fit on the side,
yeah,
right.
Before, what they had was 9 or 10 or 11 on each side, a total of 11 of those on each side. There's no room for those.
I get what you're saying.
That's why these chairs were purchased, and there's 14 of them spread throughout the sides of the pool.
Very good. Commissioners, do you have any further questions or comments? Yes, the photograph he has is new evidence,
Oh, so we
unfortunately,
cannot-
we can't
Yeah, it's
consider that
it's
new
just the new
evidence, yeah.
chairs. It's the new chairs.
Oh, so this is what
This
I
is
see
what
is
we
the,
have.
Yeah,
what we
that's-
have in our, packet is what they had, yeah.
Yeah, I have that. I wonder what's the other one.
You have a question for, I think if staff can answer my question.
No more questions, Commissioner? Do you have a question, Mr. Topchian?
I wonder his pictures are different.
Is it a question?
No, I think we're done, Commissioners. Do you have any further questions? Yes.
I believe my question can be answered by staff, but if not, okay.
Okay, any further questions for Mr. Brody?
Thanks.
Very good, thank you. We'll move on to Commissioner deliberation. Commissioner Curtis.
I'd have a question before, because it may be for that, if staff can't answer it. I'm confused about what, at the time of the hearing, does it show in here? I thought I read it, but I seem to not be able to find it right now. What furniture was there that the hearing examiner decided was there at the time this was appealed, or this was listened or heard?
So that's on page 3 of the hearing examiner's decision. She lists, there seems to be no dispute about the furniture that remained on the date of the hearing, and also the testimony about what had been ordered but not yet installed.
And I guess that's where I need some help finding it on page 3, because I am reading page 3. It's not first paragraph, it's not second paragraph.
Commissioners, it's page 25 in our packet.
It's the third paragraph on page 3, when the last sentence, beginning with when the clear fence was completed.
Thank you.
Mm-hmm.
Thank you.
Just giving commissioners time to think about things, and if anybody would like to start. Commissioner O'Keefe.
Okay, so on the question, there was a little feedback before, is this clear? There was the question of what time you measure substantial reduction from. For each person living there, it's not necessarily what they moved in. If they were provided with more later, that's the bar at which, once 14 chairs were provided, if someone lived there at a time when there were 14 chairs and those were removed, that's what we would look to. On other issues, first, I agree with the hearing examiner and staff that there was a substantial reduction in housing services for those units where we know where people moved in, so 106 and 117, because there was substantial evidence that half of the furniture was removed and half of it was in a substantially worse condition than it had previously been in. Next, I agree with staff, but not the hearing examiner, on overturning the valuation. If you removed all of the pool furniture, that would have been a $7 valuation. So if you remove half of it and half of it's in poor condition, it makes sense to have $350 for the half that's removed and $1.50 or so for the half that's in poor condition. Next, I do not agree with the hearing examiner or staff about 31 units where the move-in date is listed as unknown. For 31 units, we have no evidence of what the baseline was. We don't know if they moved in a week ago. We don't know if there were any furniture when they moved in. We don't know if when they moved in there was half the furniture there or not. We have zero evidence about when they moved in, so we don't know what that baseline is. Our job is to say if there's substantial evidence to support the decision, and if there's zero evidence, there can't be substantial evidence. In the rent stabilization regulations, it says that for quantum of proof, this is 60020. No individual rent adjustment shall be granted unless supported by the preponderance of relevant and credible evidence noted in the hearing record. And there is zero evidence about when these 31 units had people move in, so I don't know how we can say they had a substantial reduction absent some kind of evidence of the move-in date. Last hearing, I passed around the 1991 investments versus City of West Hollywood decision. That decision actually was the exact same issue for some of it. There was pool furniture that had been removed, and 3 of the people living there, they had move-in dates and they got the reduction. The rest of the people, there was no evidence about when they moved in or when they didn't move in, and therefore the decision of the commission was overturned in that case. So in that case, they had suggested that the city could use its own re-registration records to find out in such a case when all the other tenants moved in. In the rent stabilization regulations, 60013, provides that the hearing shall be conducted in a manner the most suitable to ensure fairness to all concerned parties, to secure information and documentation which is necessary to render an informed decision. And also on the next section, 60014, it says, in part, the hearing officer may consider the results of inspections of the property in question and the results of any other investigation conducted by or at the request of hearing officer. So I wish the hearing officer had requested that staff do just that and investigate all of the re-registration records to see when people were presumed to move in, so we would have that baseline. And we know if they lived there before 2009 when the new furniture came in, or before 2008 when some of it disappeared. Unfortunately, we have no evidence on the record for any of that. I know we're presented with Rent Stabilization Ordinance 17.4401, which we are advised to consider as creating an evidentiary presumption. I don't read it that way, and I also don't read it as negating the requirement that there be substantial evidence to support any decision that we make for any individual rent reduction. If you look at that section, it says, any tenant who signs the form shall be deemed an applicant. All other tenants shall be deemed applicants and shall be entitled to any rent adjustment awarded in the hearing decision. If we were to read that as a presumption, it sounds like a conclusive, not a rebuttable presumption. In other words, even if there was actually evidence that the person did not live there at the time, we would have to then grant them that relief. Clearly, we haven't done that. Clearly, that would pose serious constitutional issues. I read that not as an evidentiary presumption, which it does not in any way say specifically it is an evidentiary presumption. Instead, I read it as if, for example, our ruling is that in a case that there was a code violation, then that applies to everyone. If we rule in a case that there's a substantial reduction in housing services for those people where there's evidence they live there, then they would also get part of the judgment. So in future cases, I wish the hearing examiner would do an investigation as they're permitted to do, look for the facts, look at the date of move-in so that it can apply to every tenant who lived there at a time where there was a reduction. But unfortunately, that did not happen in this case. We could do a de novo hearing, but we would have had to notice it and do it from the beginning. In some cases, it might be worth considering if this keeps happening. But in this particular case, I think I would just uphold the decision in part for those two with the change valuation and overturn it for the 31 units where we have no evidence where they moved in.
Thank you, Commissioner O'Keefe. Sorry.
To kind of start from the beginning, I'm mostly concerned about what occurred at the time of the hearing. That's what we're here to determine whether the hearing examiner made a mistake in her opinion. So regardless of whether the new furniture is ordered or not is all irrelevant to me. That may help you in terms of meeting her order and having a determination that the rent decrease is no longer necessary, and that's something you can file through the city. But what we're here to decide is whether at the time of the hearing, did the hearing examiner make a mistake or not? And I don't believe that she did in finding that there was a substantial decrease in services. I actually disagree with my fellow commissioner about the issue that you brought up about the other units, because in this case, unlike the last case, in the gentleman, the landlord's, or Mr. Brody mentioned tonight that after the hearing examiner asked him if he would like to provide a list of all the tenants and their dates of occupancy, and he declined. He just stated that, and he did offer evidence at the hearing.
That's not what I said.
Sorry, you can't speak any longer, just, sorry.
And so I'll continue. And at the hearing, he did offer evidence of the vacant units. So again, we're looking at a very small time frame here of whether these tenants, I mean, if I think it's reasonable that if he said that there's 5 or whatever the number is vacant units, he would have also at that time said, and then a month ago there was, a new vacancy, so that shouldn't apply to them or whatever. So he had that opportunity during the hearing. I don't agree that it shouldn't apply to everybody. The issue with the 7 and 4 and 5, I'm not quite sure where. I agree that it's one service, so it should not be 7 plus 4. I don't quite understand where the 5 came from. To me, it seems like it would be 7 and then just ignore the hearing examiner's separation of the $4 for the partial decrease, because she'd already determined that the significant decrease of the lack of furniture was 7, and then she was referring to the quality of what was remaining for the 4. So I can understand voiding the 4, but I think that the $7 should stand.
Thank you, Commissioner Kirby. Commissioner Topchin?
Well, I pretty much agree with what Commissioner Kirpis have said, and well, I reviewed, and I don't believe the case that you referred is really, would fully apply in this particular case, because I agree that the landlord had the opportunity to provide any evidence or any argument to present his or her case, and have the examiner reach a different conclusion. But that was not done, and per the owner's representative, his own admission here. So I'm in agreement with the with staff's recommendation that it should not be 7 plus 4, but I agree with Commissioner Kirpis's argument that it should have been just $4 removed, and we should have applied the $7 rent decrease, and that would be it. So if the commission would agree to, if there would be a motion to maybe revise that part and keep the $7 rent decrease instead of the suggested $5. Other than that, I'm prepared to support the recommendation in this matter.
Thank you, Commissioner Topchin. Commissioner Maggio? Sorry.
Again, I think a photograph is 1,000 words, and this photograph that I pointed out to everyone in our exhibits shows the new glass fencing, which is far more attractive than the steel bars. And because the insurance company has required fencing, as they do now with all swimming pools, at one time you could get away with it, but now you cannot. There was a choice either to put ugly metal fencing or to put this glass section in, which is far more aesthetic. There is no way you could replace all that furniture now in a smaller area, in a more narrow area. You can't go through the glass. And I think we're really being unfair to the owner, because the improvement is great. They were required to do this improvement. Tell me, how are they going to put the same size and the same amount of furniture in this much smaller area? I don't see how it could happen.
Thank you, Commissioner Maggio. Commissioner Martz?
I'm going to agree with Commissioner Kirpis here. First, I don't see any constitutional issues. I really want to focus on the issues at hand and not go beyond that. I don't think this is a constitutional issue in front of us. Based on the photos, we don't have, beyond the testimony here, any evidence whether more furniture could have been pushed in there, more could not have, but based on the photos, I think more could have fit in there. But again, our role is to look at what the hearing examiner decided and see if there was a mistake made there. I don't think there was a mistake made in her decision beyond the valuation, and I agree with the recommendation of Commissioner Kirby is that the $7 is the appropriate reduction, not the 11, not the 5.
Commissioner Bergstein?
Yeah, Commissioner O'Keefe, while I appreciate the time and effort that you placed into your comments tonight, I find your arguments to be flawed, at least for tonight's hearing. While we don't have the original rent rolls to show who moved in when, what we also don't have is definitive proof, and by that it would be like a purchase receipt for furniture at any time. You know, we were told in the record that they're seating for about 18 at one point in time, and when the fence was built, there was seating for about 14. But I don't have a sales in front of me going, in 2004, the landlord purchased this many seating, that's what was in place. We're going on what's in the record. So it was approximately seating for 18, approximately seating for 14, and the time of the hearing examiner's decision, seating for approximately 4. So whatever the landlord has ordered and may be in place now is not relevant to me for tonight's hearing. It's what was in place at the time of the hearing examiner's decision. So I find the discussion of, again, no constitutional issue. I have to agree with my fellow commissioner in this, and just that there would certainly be no reduction in rent for any vacant unit. You can't reduce rent on a unit that's not bringing in rent, but anybody else, I would presume that they would have that same reduction as the rest of the tenants in the building. So certainly the landlord could move for a restoration of rent after the new furniture been in place. I'm curious as to how staff would find, because with this new construction, you can't exactly replace like for like, but that's not relevant for tonight. So I would agree with Commissioner Kirby's decision that we keep the $7 reduction in rent for all the tenants that were in place, and then remove the $4.
So maybe as expected from the last meeting, I'm in the minority here. I do agree with Commissioner O'Keefe. I do see that, for whatever reason, the Superior Court doesn't like our presumption in the RSO, and they wrote in that appeal that they wanted us to pull, the records from the city of West Hollywood and see the dates that people moved in. But there's not a consensus there to get that passed based on my fellow commissioners' comments. So moving from there, Commissioner, Topsheet and Commissioner Kirby and Commissioner Bergstein, maybe you had a different amendment, I believe, to what is in the resolution. You wanted to word this reduction a different way, or do you want to adopt the resolution as is?
Well, I think we can adopt most of the resolution as is, except for on page 2, the final paragraph. And if maybe we could just summarize for now, and staff can work out the words, but basically, we're just going to...
Can I make a suggestion?
Sure.
I was just going to suggest that last sentence, just say, since administrative precedent values pool furniture at $7, staff recommends, or commission reduces the rent by $7, and then just cross out the rest of that sentence. Would that suffice?
And that would also apply on the first page with the bullets.
For the findings of fact, yes.
Yeah, it's almost identical. The hearing examiner did write in her final decision, the record supports a valuation and rent decrease of $7 based upon the pool furniture that was eliminated, just very specific. So pretty much what you said, but we're talking about the stuff that was eliminated, not necessarily the whole service.
Got it.
And then that's what I would move.
Commissioners, any further comment, or do we have a motion?
There was a motion, right? Then I second it. I'll second
Do you
it.
want to formally? Okay. So we have a first from Commissioner Kirby and a second from Commissioner Topshean for the resolution as amended. Secretary Briano, may we have the roll call? Well, before, any further commissioner comments about the motion on the table?
Not really.
Okay, very good. Secretary Briano.
Commissioner O'Keefe,
No.
Commissioner Kirby,
Aye.
Commissioner Maggio,
No.
Commissioner Martz,
Aye.
Commissioner Topchian,
Aye.
Commissioner Bergstein, or Vice Chair
Aye.
Bergstein. Chair Charity.
No. So I believe it passes 4-3, so it does pass. Parties, if you have any questions about what was done tonight, please address the staff, and they'll be more than happy to help you. We're moving on from Appeal 9A to 9B. That is D-4397. The address is 1007 North Laurel Avenue, Unit Number 9, This appeal was filed by Mr. David Israeli. Mr. Israeli, are you present? No?
Excuse me, sorry, the owner is not here and asked me to tell the commission that they had to leave, but that they intend on replacing the carpet. That's what he asked me to tell you.
Thank you very much. Our tenant, Ms. Bree Ely, are you here? Present, thank you very much. So at this time, we'll have our report from our staff attorney, Ms. Allison Regan.
Sorry about that. Tenant Bree Ellie has lived in Unit 9 since November 2013 and pays approximately $1,600 in rent each month. She filed an application for a rent adjustment based on the failure to replace the carpet. The hearing examiner granted a rent decrease and found that because the carpet was more than 7 years old, the maintenance requirements required the landlord to replace it. The landlord appealed and claims that the former tenant's dog damaged the carpet, and therefore the landlord is not responsible for the replacement of the carpet. Staff recommends that the commission affirm the hearing examiner's decision. The ordinance is clear that landlords are required to replace carpets every 7 years. Thank you.
Thank you very much, Ms. Regan. Commissioners, do you have any questions for Ms. Regan? Not at this time, very well. Ms. Ely, you'll have 5 uninterrupted minutes to speak to us.
I was hoping we didn't have to meet like this. My name is Bree Ely. I live at 1007 North Laurel Avenue, apartment number 9. I was really pleased with the hearing examiner's determination that without any kind of record of when the last carpet change happened, that we would just move ahead and make the change happen. Then the appeal comes, then we have another 2 months. In the last week, the owner came by and asked to inspect, and I just thought it was probably a run-up because we knew that we had this event happening. And now for them to say while we were here, in a kind of disrespect of our time and your time, that they were just gonna go ahead and replace them, all right. But without there actually being some kind of determination as to what the deadline is, what the consequences are, I feel like they're gonna just give us and you the runaround. I would love to know if the deduction will actually be put in place and put in retroactively from when it was filed in January. That would be dope. And then just to make sure it stays in place until the actual maintenance is done per the city's code. Just, yeah.
Thank you, Ms. Ely. Commissioners, any questions? No questions? Very good. Thank you very much. We'll move on to commission comments. Commissioners, who would like to start?
Questions or comments? Well, I find this argument made by the landlord really laughable, that the previous tenants, this tenant is responsible for the alleged damage caused to the unit by the previous tenant. That's just really, it's just laughable, if not to say more. Yeah, this is one of the easiest cases we ever had, because clearly under the ordinance, the owner will be responsible to replace the carpet, and if it's not done so, there should be a rent decrease, and that's what was determined. And I think the examiner's decision is correct, and I fully agree with staff's recommendation. I'm going to support the findings of the examiner.
Commissioner Maggio.
Like her question asked if it is retroactive.
Staff?
We can respond to tenants' questions afterwards.
Thanks very much.
Then I will just go on to say that I agree with the staff report, and yes, carpets have to be changed every 7 years. It's the law, and apartments have to be painted in the interior every 4 years. That's the law, although it doesn't apply here. But those are 2 things that come to us the most, and yes, you need to have your carpet replaced.
I have a brief comment. I agree with everything my fellow commissioners have said. I think this is an example of how not to act as a landlord. The law is in place for a reason. It's very clear that it was not followed in this case. I would just like to say to you today. You know, as much as we would love to rush these things, this is the slow pace of justice and courts and government. And, you know, the nice thing about being in a city that's as small as West Hollywood is that it actually moves quickly. I'm an attorney, and some of my cases don't even get their first court date for 2 years. So as much as that is a terrible thing to say, you know, hopefully at least tonight is a little bit of justice. So I would just agree with my fellow commissioners, and that's it.
Commissioners, anything further? Any more comments?
It's very straightforward, and I agree with my fellow commissioners.
Me too. Do we have a motion?
Wait, I had a
Sure.
couple.
Commissioner
Sorry.
Bergstein, thank you. It's
So
fine.
I'll be voting in favor of staff's recommendation, but I just wanted to make a few comments in general about the situation to any other landlords and tenants who may be watching tonight, because if I read the record correctly, the original tenants moved in July of 2011. One of the original tenants, there's no record of the move-out date. Another tenant moved in 2013, but there's no new leases, at least in our record, for those, I guess I would call them a successor tenant, for lack of a better word, or move outs from the original tenant. So I think the landlord lost the opportunity for a post-move-out inspection of the unit, which might have turned up if indeed the original tenant's dogs had damaged the carpeting and the carpeting was relatively new. If the landlord, at that point when those tenants moved out, an successor tenant moved in, I'm going to do an inspection, as soon as you're out, could have dinged that original tenant for that damage to that carpeting. But there's nothing, at least in our record, that shows that there were any new leases signed by any successor tenants. There's nothing about any inspections, nothing even in the record about what happened to the initial security deposit. I don't know if the successor tenants just paid the original tenants for their portion of the deposit. So I think there were lost opportunities by the landlord in this case to have apportioned for any damage to the original tenants that may or may not cause the damage, and there lost opportunity for any of the newer tenants when they moved in to go, this damage is existing. So I'm going to be voting in favor of staff's recommendation, but just kind of as a cautionary going forward for all tenants and landlords, when there's a change in tenancy without evidently a change in a lease, there should be an addendum, a new lease, an application, something to really clarify who's living here, who has a security deposit, who's responsible for this damage.
Thank you so much, Commissioner Bergstein. Thank you, Commissioner Raggio.
Therefore, the Commission will adopt Resolution RSC 19-550, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision in D-4397.
I will second that.
Thank you very much. Secretary Barino?
Commissioner O'Keefe,
Aye.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Bergstein,
Aye.
Chair Charity.
Aye. Thank you very much. So the motion does pass. Parties, you had some questions, and staff will be more than happy to answer those for you. Moving on from our appeals, item 9 to item 10, public comment. I don't have any public comment before me at this time. Moving on from item 10 to item 11, commissioner comments. Mr. Kerpes?
Just want to mention that today is Victory in Europe Day, celebrated by many of our Russian-speaking residents. So I want to, I don't know if you say Happy Victory in Europe Day or not, but I want to recognize that. And I did get an opportunity to go to the Victory in Europe Day memorial walk and ceremony on Sunday morning, which was very nice. And it was a great ceremony, and it was good to see everybody.
I have a, may I? I'm going to do this for Agassi, that not to forget Sunday, May the 19th, which is the 18th annual Russian Arts and Cultural Festival, which is held at Plummer Park. There's, of course, authentic Russian food and a wonderful gala, and I believe there's going to be a special guest, Liama, how do you pronounce her last name?
It's Laima Vaikule.
Vaikule. And also Commissioner Topchian will be singing, and he has a great voice, so I hope everyone will attend.
Thank you so much.
Thank you, Commissioner. Yeah, thank you, Commissioner Maggio, for those comments. And I'm not sure if the camera will capture this. This is the official kind of a card from the City of West Hollywood and its Russian Advisory Board present that 18th annual Russian Arts and Culture Festival. So there are a lot of activities, a lot of interesting things, a lot of fun on Sunday, May 19th in Plummer Park from 11 a.m. to 7 p.m. And as Commissioner Maggio mentioned, we have a number of special guests, among them really big Russian, Latvian singer, pop diva, Lima Vaikula. She is exclusively coming to West Hollywood to perform on that day. We also have a performance of Gay Men's Chorus of Los Angeles on that day from about 3 p.m., if I'm not mistaken, to 3:30, and after that, the gala concert will begin. So it's a really, it's a good opportunity to join the Russian community of West Hollywood on that day. As I said, there will be a lot of entertainment, a lot of activities for children. So everybody is welcome, no cover, free parking. So just come and have fun. Thank you.
Thank you so much. Commissioner O'Keefe.
I wanted to announce that May is Bike Month, and there will be 2 events for Bike to Work Day. On Thursday, May 16th, the City of West Hollywood and the West Hollywood Bicycle Coalition, of which I am a member, will be holding a pit stop for folks on the way to work with refreshments and coffee and swag and stuff like that at Santa Monica and Westmount from 7 a.m. to 10 a.m. and Mid-City West Community Council, which is part of LA City, along with also the West Hollywood Bicycle Coalition, will also be holding a bike pit stop at Willoughby and Vista around the same time from 7:30 to 9:30 a.m., I think.
Thanks very much. Commissioners, anything further?
Yes, I have a real quick. I went to the city council meeting on Monday. A few things that affect generally housing. They are looking at changing the housing in lieu fee for affordable housing. And they all opposed SB 50, which is Senator Scott Wiener's zoning and planning big law. So those are some things to look into. That's a huge change to how the state handles housing planning and local versus state laws. It's contentious, but the city did oppose that 5-0. And then LA Pride is coming up. They are going to expand the footprint. All of basically this area is going to be closed down, which is different than in years past. So it'll be a change. They're going to test it out and see how it works. It's costing the city a lot more money, but I'm in favor of it and hope it turns out well.
I'm in favor of it too. It was really jammed last year. Commissioners, any further questions or comment or anything? Okay, very good. We'll move on from item 11 to item 12, staff comments.
A few comments.
Thanks.
Things do sometimes move a little slower than we'd like to. And so some of the commissioners, I don't think were on the commission when Commissioner Bergstein brought forward a non-smoking ordinance and led the commission through a discussion with a question to the council whether the council should look at that. And the council did give a nod to staff to please bring back an item for discussion and for their consideration. I wanted this commission to know that that is steadily moving forward with code compliance, and I'm working with Dan Mick on that, one of the code compliance officers there. And so I will let you know when that item is coming forward to the council. The item would be looking at other programs that are actively and around the city of West Hollywood and seeking some direction from council on how they would like to proceed. Additionally, and separately from that, the zoning text amendment regarding the length of tenancy, that was postponed till June. I believe it's the second meeting in June. We did have an opportunity then to take that question, the commission's question, to the subcommittee on the council that reviews commission requests and ask them if the Rent Stabilization Commission should review the item before the council, and the committee said no. So that item will go, will just continue to proceed to the council without coming to the commission. However, I also have raised the question about the duty on housing policy, evaluating and recommending on housing policies. I raised that to the city manager and to the city attorney, and we also kind of floated that in front of the subcommittee, which is the mayor and the mayor pro tem. And so at the commission study session, I'll lead a discussion with the commission on what you see as your role is in evaluating and recommending on housing policy. I think we'd like to first hear from you, from the commission as a body. We do need to be aware that it does bleed over and overlap with other commissions. There are other commissions that clearly have housing roles. There is one commission, the Planning Commission, that has the responsibility delegated to it from the state to review housing policy. So I want you to know, though, that we wanted to start here with the commission. We wanted to hear your thoughts and perspective on what that meant, and then we would take that forward to the council for their consideration and direction on what the role should be. Those are my comments.
Commissioner Bergstein.
I don't know if you want to touch on this postcard before we finish up tonight. And then secondly, I didn't watch most of the council meeting on Monday. I was out of town. I think there was an item on the consent calendar, a discussion about relocation fees for non-rent stabilized units. Did that get pulled from consent or passed?
It was pulled. It was discussed and excluded consent. This will be an exploration of creating a relocation fee requirement when tenants receive a greater than 10% rent increase in non-rent stabilized units. And so as we work on that, we will bring that to the commission. And so you can have some review of that item as that goes forward. It will start with a review of what we can do. I think that the genesis of this came from Long Beach. And Long Beach was looking at something similar to this. Now, Long Beach doesn't have rent protections, it doesn't have rent stabilization, and it doesn't have, I don't believe that they have just cause eviction. I believe that Glendale has some form of a relocation requirement without having rent stabilization right now. And so there's those are just two examples of this form of requirement that's out there, but they're applied in jurisdictions that don't have the stronger rent controls that we have here in West Hollywood. So we'll have to look at what that really means here locally, but that is an item that will be going forward. Now, you also held up a postcard. I don't have one in front of me, so I didn't know that you had one. Maybe you received that in the mail because you're a landlord. But we are hosting landlord training sessions on our new and upcoming online software. This is so our database, our registry, it's old, and it's so we've been working over the last year or so to replace that, and the new system is about to be rolled out. That new system it allows for online registrations, and so these are training workshops for landlords to start the process, teaching folks how to register their tenancies online. In addition to this, we're setting up a kiosk. We'll have an iPad in City Hall, so as folks come in, they will have the option to either drop off the paper forms or they can just enter the information right there, receive an email that everything's good and their registration's been submitted. And I think that this will address one of the commission's concerns in the past, which is that there's no questioning that the proof that the registration was submitted and received and processed in the system.
Would there be a way of doing a demonstration here at the commission level once that's up and running?
Yeah, let me see if we can do that. I believe that we should be able to, since we're designing it so that it can be used on mobile devices. Absolutely. So we'll see what we can
Commissioners
do.
agree that might be a good thing for us to look at?
Yes.
Once it's up and running?
Peter, I had a question for you. Now that I'm going out as liaison to so many of the commissions, and I think we did it once before, do you think I could get my hands on some of the guides for tenants and landlords, our booklets? I think one is green, one is orange.
Of course.
Can I get maybe a dozen of each so I could?
Of course.
Okay. Thank you very much.
Just a quick one to clarify, Mr. Noonan, you mentioned about the smoking going off and off. That discussion will become before the City Council, and are we going to have a chance to review what would be recommended by staff before it goes to the City Council, or misunderstood that part?
Thanks, yeah, and thank you for the question, because I do want to clarify that there's no recommendation from staff at this point. What the item that the council asked us for was to bring information on what other programs are out there. So for the commissioners that were here when Commissioner Bergstein brought this item forward, you may remember that there was a packet of information that included the Beverly Hills program, Santa Monica program, Berkeley program. Essentially, we're just putting that information together and summarizing that in the report, presenting it to the council and asking the council how they would like staff to proceed.
And after that, maybe the commission will have an opportunity to kind of discuss if council's recommendation would be to adopt something or draft something. Because I personally have a lot of concerns when it comes to the smoking possible.
Absolutely, and we'll raise those concerns. And certainly, there's been I won't have the date correct. I believe it was 2009, but I apologize if it's not correct. That this had come up, and there was a change made to the RSO that was very clear that smoking couldn't be considered a nuisance for the purposes of an eviction. So, yeah, we will roll your concerns into that item.
Commissioner O'Keefe.
Thank you for the update, Mr. Noonan. On the zoning text amendment, you mentioned talking to the subcommittee and that they said no to referring it to us. Ms. Regan, I believe you also emailed the full council, and I just wanted to confirm that happened and the full city council has also seen the request.
So I emailed the request to the city clerk, Yvonne, to transmit to the council, and she transmitted it to the city staff, and then they determined that it was to go to the subcommittee. So as far as I know, it did not go to the full council, it went to the subcommittee.
I think we as a body wanted it to go to the entirety of the council. So I believe that what our resolution was to ask the council as a whole, but I'm not sure. So are people satisfied with it going to the subcommittee, or do we want to have...
Well, it's clear to me that we have this tension between, being an adjudicative body or a legislative body. And it seems to me that City Council is happy to kick things to us, but not happy to, take things from us with every recommendation we may have. So, I guess my overall question is, we were turned down by the subcommittee, we were turned down by the planning committee for, a presentation on the issue. For us to, even recommend or discuss what we think our role should be or what we want to do, is that even useful for our time? Because it seems as though that in practice, what's happening is that they want our opinion on housing policy when they kick it to us, and then they would rather not have it when they don't. I guess from your comments, you said it was worth our time to have the discussion, but...
I think that, this originated in 2005, and I want to recognize that Commissioner Kerpes was the gentleman who wrote the report as deputy to Councilmember Prang. And so I know that there's been a real interest over a very long period of time. As far as I could tell when I went back and looked into the histories, and I believe Commissioner Topchin was here on the commission at the time in 2005, that there wasn't as strong of an interest among all of the 5 commissioners to take that role on or to further develop what that role meant in terms of housing policy. If you remember, in 2005, we were kind of facing the same dilemma that we're facing now with housing and housing affordability in California. And then 2007-8 happened, and there was a huge crash, and the immediacy and the real visceral importance of addressing our housing in many ways went away. And without, I'm assuming, or I'm kind of reading into the histories here a little bit, that perhaps without that strong impetus on the commission, what I had heard at the staff level was that Commissioner Sue Buckner, she had been on the Rent Stabilization Commission at the time, had been the one that was really pushing for housing. She went to the Planning Commission, and with that, a lot of that impetus, the drive for it went away at that time period. Well, it's come back. Unfortunately, between 2005 and present, no one has really articulated what it means in terms of a role. And for me, to be quite honest, I want to be honest on staff's perspective, it would help us to know where we take items, because when you're working on something like a zoning text amendment, my history and background is in community development, and I've done plenty of ZTAs, and you really need to plan ahead where you're taking an item and know where, because you have certain timelines and due dates that you're meeting. And so if it, in the least, it would be helpful and beneficial to staff to understand what we're doing and where we're going with an item.
And just to clarify for the commissioners that weren't here, council did ask for our opinion on housing policy for that earthquake retrofit business, correct? I mean, they did send that to us for our opinion, correct?
They did.
Right.
Yeah.
So it happens occasionally, but there's not really, to get back at Commissioner O'Keefe's question, there's not some set formula for us elaborating on housing policy and getting it to council through the staff. Is that kind of,
That's the purpose of starting the conversation here, because when you say, case in point, when you say housing policy, to me, it means a very specific thing. Within our general plan housing element, we have housing policies, and we update those housing policies every 8 years, consistent with state requirements. They're reviewed by HCD, it's certified, and then we move forward. We enact those housing policies through our programs, and so each year we submit an annual report that's addressing and telling the state how we're meeting our housing programs with the intention of addressing our housing policies. And so with that statement in the duties, I would immediately assume that it is related to that role and aspect and function, which is quite a process when we update the housing element. But I think that I've also heard housing policy being used in a much broader sense than what I would understand housing policy to be. And so I think that the intent here is to hear during the study session, to hear what your perspective is and your understanding of housing policy and how you would have a role, so that we can then present that to the council, confirm with the council that that's their understanding. And in between that, and in our conversation, we can also refine this so that it fits within the realm of, that it doesn't overlap with the Planning Commission, it doesn't overlap with the Human Services Commission, and that it is a role that isn't being currently filled by one of the commissions in the council, in the city right now.
Thank you.
Peter, in our definition of rent stabilization, there's one word that we seem to always are not clear on, and that is promulgate. And I think at some point you thought we should look at that word, or
Not me. It is a word. I would hope that when we have this conversation, I think that it's important for the commission to remember that your primary role is as the appellate body for rent stabilization. Now, if we wanted to look at the word promulgate and what that means, I think that we could do that. And the intent here is really more to define that fourth duty on housing policy.
Thank you.
One comment on the question of multiple commissions touching on the same issue as maybe being a reason that the zoning text amendment wouldn't go to us. On the bike advocacy stuff I work in, it's not at all unusual for the same issue to go to many commissions. For example, they're talking about how to extend the close the gap in the Santa Monica bike lane between Beverly Hills and Almont, and that's going to 3 different commissions. It's going to transportation, public facilities, and arts and culture. So I don't see that necessarily as a barrier, because it's very common to have multiple commissions have jurisdiction for their own piece on the same issue.
Commissioners, any further comment or question for staff?
I have one. I think City Council has made it relatively clear what they expect of us, with whether they've accepted our comments and our thoughts or not. And at the end of the day, we are a commission under the City Council, and from what I've heard from City Council members, staff, whether they say it outright or not, is that we are an adjudicative body first, and policy is second, if not third or fourth to other things. So I think we need to all kind of take a step back and recognize that the City Council has made some of these things clear to us, and that we may need to let staff have these conversations that they have said they're going to have with the subcommittees, speak in our study session and maybe not put the brakes on things, but slow down with kind of the way we are pushing forward, because to me, it's not being well received by City Council in talks with my council member, other council members, and other staff members. So, you know, everyone is obviously free to do what they want, but perceptions are important as well to our commission.
Commissioner Kirby.
I'll make it very short. I just wanted to clarify, as I first said, you know, there's a view that councils kick things to us when they want to hear things, but you kind of implied that they don't want to hear from us on things that we want to send to them, and I don't think that's an accurate picture at all. I don't think that the commission has found a way yet to effectively send recommendations to the council. So I don't know of any examples where that statement would be supported. But I'll just leave it at that.
No, thanks very much, and this is why we're going to hash it out in that study session and figure out what we're going to do about this. We'll get down to it. Commissioners, anything further for staff? Very well, we'll move to adjourn. The next regular meeting of the Rent Stabilization Commission will be held on May 23rd, 2019 at 7 p.m. in these council chambers. Meeting is adjourned.